morning, everybody. I think we need to get rolling here. I had so forgotten the trials and tribulations of the trip on I-95. So much fun. Sorry about the late start, but I promise I'll have you out of here on time and we'll be back on schedule. I want to welcome all of you to the Superyacht Law Summit, part of our continuing series of seminars intended to enlighten and considerable benefit to our membership, I might say. With all the lawyers that we have here, I wonder if any of them have ever heard of the lawyer's paradox. Anybody? Raise your hand. No? Good. All right. Lawyer's paradox was A.K. Griffin, who said, if it were not for lawyers, we wouldn't need them. Okay? That sounds negative. And of course, I could sit up here and tell a few lawyer jokes like everybody could, but I'm not going to be as pithy as that because we do need them, all right? So often it happens, our deals stall, all on points of law that can disrupt until interpreted, counseled by our legal practitioners. And we welcome you all, attorneys, brokers, and all those folks who engage in this art of selling yachts. So it takes a team, not a village, but a team. And I'm Bob Saxon, I'm your moderator here today. And I had a lawyer, Jim Porter was his name, rest his soul, Hodgson, Russ, Andrews, and Goodyear, an old firm out of Boca. And Jim used to say to me, well, I'd say, Jim, I need your opinion. And he'd sit back, take his glasses off, fold his hands across his chest, and he'd say, let me tell you a story, Bob. And that's how he always proffered law to me. So today we have a series of stories. We have a series of panel discussions for your pleasure and for your edification. And we've assembled a who's who in the legal profession, as you'll learn as we introduce our notables. Our format will be 2 panel discussions. Then there'll be a networking break. I'm going to probably have to trim back on that networking break just a little bit because of my tardiness. And then we'll have 3 panel discussions to follow up till noon. There'll be Q&A. Q&A is intended to edify, not meant to allow people to give speeches, but to illuminate on our subject matter and take advantage of our experts. And so my intention is to be prompt here today and keep us on schedule. I want to talk about our sponsors quickly. They support us to allow us to conduct these seminars in these great confines here on the day of the opening of the great Palm Beach Boat Show. What's great about our sponsors is, though, that it's not just a matter of benefiting from the exposure, but also they believe in our mission. They believe in the mission that the IBA to foster professionalism, good ethics, and to work in tandem in our industry in a positive work environment. And our sponsors today are Robert Allen Law, Ali Maass, Moore & Co., the Marshall Islands Registry, NFP, and their dedicated team of insurance experts, Schutz & Bowen LLP, PG Legal, an international legal team, JP Reynolds Customs Brokers. To begin, we'll be opening our session with an IYAC rules update, International Yacht Arbitration. I'd like to introduce Charles Anderson quickly. Charles and I have worked a little together intellectually on the case, but 90% his intellect and about 10% mine. He was served for 23 years as vice president and head of Scope North America, the U.S. subsidiary of the Norwegian B. Scold P&I Club, during which time he handled numerous cases for yacht and superyacht owners and charters. Their bio notes are here. Look in your program. And with that, I'd like to have Charles Anderson come forward.
I'm going to use the podium because I have some notes. Oh, thank you. You all set? Okay, good morning, everybody. As Bob said, my name is Charles Anderson, and this morning we're going to be discussing the revised IYAC arbitration rules. The existing rules, as you all probably know, are pretty comprehensive, but they were modeled on the UNCITRAL rules, and there was a a feeling that we really needed to have more bespoke rules for the yacht industry, specifically to make dispute resolution more efficient and cost-effective. I should emphasize before we start that these are still proposed rules, so they're a work in progress. But we thought it would be helpful to give you a little insight into our thinking on some of the more important changes that are under consideration. But first, let me introduce our panel members, and they probably don't need any introduction at all, so I can be very brief. Our first is Bob Allen, who, as you know, is a senior partner at Robert Allen Law. His practice focuses in large part on the yacht industry, and he has advised the largest yacht manufacturers and owners on their operations in the US, the Americas, Europe, Asia, and Australia. Then we have Robb Maass, who heads the Ali Maass Rogers and Lindsay Maritime Department, which specializes in yacht transactions. And Robb represents a very broad spectrum of yacht owners, manufacturers, crew, brokers, and vendors. And last but not least, Joe Stanley, who is a fellow of the Chartered Institute of Arbitrators, with very broad experience in commercial and maritime arbitration and mediation for institutions such as the AAA, FINRA, and the Florida court system. She's also a litigator with 20 years of experience focusing on commercial, employment, and insurance law. So each of our panel members has had extremely extensive experience with disputes, also expensive. It's a slip of the tongue, sorry. But cost-effective, that deal with yacht purchase and sale agreements, construction contracts, charters, crew contracts, and probably a host of other things. But I'm going to start with a general question, because we have Bob Allen and Robb here, who are basically there at the creation of the 2001 rules. And I want to start perhaps with Bob, just to give us a general overview of why we should choose IYAC arbitration over litigation.
Well, it starts with a story. We were hired by a brokerage to help them in a commission dispute. And I remember the amount of the commission that they were seeking was $210,000. And because people like to fight, particularly on principle, particularly very wealthy people, it turned out that our fee, after about 2 years, was $160,000. And, you know, I guess that was good money for the law firm, but it didn't make any sense whatsoever. And that was the beginning of a journey, really, that kept me looking. I'm a transactional lawyer. Our firm does litigation. Every time there was a dispute, it seemed like the fees for brokers way exceeded the value of what they might expect to receive. And then I got involved in a case where it was a charter dispute, and somebody didn't like the food on this charter, and it was $1 million a week charter. And under the MEBA rules, there is it just doesn't work. You have to go to London. We ended up, our side, hiring a lawyer in England, and then they hired a Queen's counselor. And then the other side hired a Queen's counselor, and all of a sudden the arbitrator was a Queen's counselor, and it was under London Maritime Arbitration Association rules. And because somebody got a bad experience with food, which was probably because they ate off the ship, and then ended up costing, just in I guess in the settlement, it was like $250,000, and add to that all the attorney's fees. And I figured we must have a system where brokers can have their disputes resolved primarily by brokers and lawyers who know about yachting, as opposed to going to London to deal with arbitrators who mostly know about shipping.
Thank you, Bob. Any other comments?
Well, I'd say that it may have begun with the concept of assisting yacht brokers in resolving disputes, but now you see it the purchase and sale agreements. So it's not necessarily confined to brokers, and it's just becoming more widely accepted. We have had, I don't know how many, like 16 arbitrations so far, something like that, and the number is growing. I expect it to grow further. So it really provides a comprehensive dispute resolution procedure, which I think we're going to see more and more being used in more and more different contexts.
Joe, anything?
No, I agree, and obviously our goal with arbitration, not only in this forum, but across the globe, is a sort of expedited, more efficient, streamlined process that is, of course, a cost savings benefit, but also, time. Time is money, and giving everyone an opportunity to get in front of folks who, as I like to say, know what the pointy end of a boat is called.
Okay. Do we have a slide with the comparison of the rules? Great, thank you. So we have a draft comparison of the existing rules, the 2021 rules, and the new proposed rules. We're not going to go through every one of these in detail, but just highlight some of the most important changes. The new rules provide for a three-tiered approach to claims. The first would be what is called document arbitration for disputes of $250,000 or less. The second would be the so-called standard arbitration for disputes between $250,000 and $1 million. And then the third is for more complex and technically complicated disputes. I'd like to ask Rob, how do you think this approach is going to make yacht arbitrations more efficient?
Clearly, the larger, the more amount in controversy, the more complexity you can justify in terms of cost and effort and so forth. And so the idea is to try to put cases in context, and the smaller cases can be resolved in a somewhat different manner, hopefully less expensive and quicker. And in the very large cases, we will always have 3 arbitrators. It will be a somewhat more involved process, but it tailors the arbitration procedure and cost to the amount in controversy, which I think is a good idea.
Thanks. Any other comments?
I'll just point out on the January 2021, where we're talking about number of arbitrators, the existing rule is, that's, I think, for the top tier, the default being 3. For the simplified or lower tier ones, it was a sole arbitrator is the existing rule, unless, which is appointed by the parties, unless they can't agree on the identity of that sole arbitrator, then the council picks the sole arbitrator. So that's just a little tweak on that slide verbiage there.
Okay, thanks for that clarification. Can we have the next slide? Yeah, I wanted to address the last bullet point there, and that is the ability of the arbitrators to award emergency relief. So I think this is quite an important new feature of the rules because lawyers and their clients enter into arbitration in the hope that if they win the case, the losing party has the assets and the means to satisfy an award of damages. But on occasion, claimants have to weigh the cost of arbitrating the dispute against the possibility that the respondent will become judgment-proof or insolvent. So awards by arbitrators can include posting of security pending arbitration as part of their general trend towards favoring interim awards. But when there's a risk that assets may be dissipated or that evidence may be destroyed, often you can't wait until the formation of a panel. So these new rules will give the IYAC the ability to appoint an emergency relief arbitrator to help ensure that any orders that the panel may ultimately direct, there will be enough security in hand to cover the costs and also to preserve any evidence. And I should emphasize these are enforceable by the courts, even though they may not be considered exactly a final award. They do have enough finality to be enforceable. But I found in my experience that very often the counterparty will voluntarily comply. Number one, because they don't want to risk the ire of the panel and not complying with an order, and also they don't want to have to be responsible for the costs of enforcing the order. Some of the criteria for posting the award you're probably familiar with, but there's an overall objective here of making sure that the arbitrators do justice and equity between the partners so that the winner of the arbitration is not faced with a so-called Pyrrhic victory. We also look to see whether there's enough evidence to establish success on the likelihood of the merits, and also the opposing party's conduct. If it refuses a demand for arbitration, or if there's a continuing breach of contract, that can be grounds for awarding emergency relief. And obviously, the opposing party's financial condition, creditworthiness, physical assets, corporate restructuring sometimes is a factor here, or the transfer or sale of assets. And also, I should emphasize that counter security is available because the arbitrators want to make sure there is a level playing field. So if relief is demanded for pre-award security, the counterparty has a right to make a similar demand for counter security. So I think that's going to be a very effective part of this new rule, which hopefully will be of value to yacht owners. The next thing we wanted to talk about is a new provision which deals with the use of artificial intelligence to ensure that its use doesn't compromise the confidentiality or integrity of the evidence or fairness of the proceedings. So I wanted to ask Joe, how do you think AI can be used effectively in arbitration?
Well, let me see what my AI told me to say here. Yeah, I think that, of course, AI is a tool for efficiency, and it's very important that arbitrators and advocates realize it will never be the substitute for human judgment. Certainly isn't going to be the substitute for the decision maker. And in yacht arbitrations, we can use AI for organizing document-heavy or large cases with a big record, collating things, summarizing documents, doing comparisons of contracts and terms, and getting an ability to have a view of that. One of my favorite uses would be for timelines. Obviously, in this industry, timing is everything, right? When was the acceptance? When was the closing date? When was that email sent? When was the contract amended, and things like that? And AI can be used to sift through loads of correspondence and documents and what have you to create a broad, comprehensive view, not only for the arbitrator's ease and efficiency, which, again, time-saving, cost-saving, but also for the parties to get sometimes a clearer look at exactly how their particular dispute plays out. So I do think it's a great tool for efficiency. I'd like to point out that it's notable that IYAC, the IYAC, is doing what I think is a forward-looking inclusion in the rules about the use of AI. A lot of other institutions are dealing with AI, sort of just still reeling, really, and dealing with it as guidance more so than actually codifying it in some rules. So I think it's a progressive forward look to dealing with this type of issue. And the challenge is, of course, crafting a rule with language that is flexible enough but meaningful enough to withstand the evolution of this technology, which probably while I was talking, there was an update to ChatGPT and everything I just said is meaningless. But I applaud the IYAC for including the use of AI. And I think we're going to probably hear a little bit later about the risks of AI, of course, confidentiality, as you mentioned, accuracy, over-reliance, and I believe that we'll be hearing a little bit more about that later on, concerns of unreliable evidence making its way into the record.
Will you show me how to do all that?
Absolutely, for a small fee.
Well, I don't want to get into the risks too much, but I'm a very newcomer to AI, and I have used it recently just to see if it can give me some insights into issues that may come up in arbitration. And I was astounded that within a matter of seconds, this tool can come up with citation of cases and even ask you if you'd like it to write a brief. But there obviously are great dangers in doing that, and I know that some lawyers may be tempted to over-rely on it, and I found that not all of the information, particularly on the case citations, is accurate or relevant. So you have to be very, very cautious about using. But it's a very interesting tool, certainly, for arbitrations, and I'm sure its use is going to continue. Do we have another slide? Was that the last one? Oh, yep, sorry, go back. You got it. Consolidation and joinder, this is a new provision. You find this in a number of other arbitration rules for other organizations, and I think it's certainly useful. It may not be so useful for the yacht industry in terms of consolidation. I mean, this tends to be more in the commercial area of cargo and commercial charter parties. But certainly the power of the arbitrators to join non-signatories is important, provided that there is an agreement to join the parties, or if there is no agreement, the arbitrators can employ certain principles to bring in non-parties, such as agency or estoppel, or assumption, ratification, and in some cases, corporate veil issues can come into play to bring a non-party into the dispute. So I think it's a very, very a good rule to have in place, and one that could probably be of assistance in a lot of yacht arbitrations. I guess the last, maybe not the last, but the second to the last issue we wanted to bring up is mediation. The rules don't have any special provisions for mediation, but as we all know, it's increasingly used in all sorts of commercial arbitrations, and so I think consideration will be given to putting in some special rules for mediation. And I'd like to ask Joe, who has certainly had extensive experience in that area, to comment on whether or not she thinks that this will be beneficial in resolving yacht disputes.
Yes, I do think, and I have thought for a long time, that the industry needs a sort of formal avenue for mediation. The yachting industry mediation is perfectly suited. We're a relationship-driven industry, and in sort of more formal adversarial settings like litigation and even arbitration, positions can get entrenched, parties can dig their heels in, and bridges get burned, and folks get into that scorched earth sentiment, and we all work together and end up seeing each other again over and over and over at boat shows. So mediation has the ability to preserve those relationships, not just for the individuals who are directly conflicted, but also for that ripple effect, their employees, their staff members, and so forth, who may feel that they need to take sides where litigation has been initiated. So with mediation, what's also very useful is that the parties retain control of the outcome. Unlike litigation, unlike arbitration, the mediator is not a decision maker. He or she is just there to facilitate the conversation and hopefully help the parties move toward the right decision for them, which may be impasse, but hopefully in some cases would be resolution. And I find that when parties work together to craft an outcome, there is a lot less hurt feelings. And, and usually the parties I've found in my experience are often way more creative than an adjudicator or a judge or even lawyers can be about how outcomes or resolutions can be held. So, and again, mediations in Florida Supreme Court certified mediators such as myself are bound by confidentiality. Those mediations are confidential as well. And so you retain reputations and things like that also. So I'm excited that IYAC is taking this position. Again, it's forward thinking, and as you mentioned, many other commercial institutions are using mediation as a complement, not a substitute, for arbitration. A lot of disputes don't necessarily need the full protocol of an arbitration for perhaps smaller commission disputes, things like that. So, yay mediation.
Yeah, I have a comment on that. But first, I'd like to know how many yacht brokers are in the room? So we have a bunch of you, and most of you are concerned with commissions. That's really what it boils down to. And I've recently mediated a case that involved 3 brokerages and brokers within them, and the sums, which sometimes, if you're extraordinarily lucky and you're only dealing in mega yachts and super yachts, then the sums justify hiring a bunch of lawyers and doing all this stuff. But most of the time, you're not fighting about $3 million. Most of the time, you're fighting about $100,000 and who gets it. And a mediation, when I was engaged, it was kind of an interesting mediation. Basically, they said, hey, Bob, you know the rules. How do you think this complicated scenario should work out? I made my analysis, and I basically said, these are your options. You can solve it this way, which seems to be fair, or you can fight about it. And if you fight about it, you're going to be spending a lot more than this. And they ultimately, these brokerages worked it out. And in this industry, it's just like the lawyers, right? We get along. When we have a problem, we have disputes or disagreements from time to time. Our clients are opposed. We kind of work it out. We work it out. And the people that run these brokerages, there's very few that operate in a world where they don't give a hoot about what the other brokerage thinks about them. Obviously brokers themselves are fighting like crazy, but the people who run the brokerages, who ultimately have the legal right to bring or not bring the dispute, they basically want to get along. They've had long-term relationships. So mediation is a phenomenal idea. So you hopefully only involve, potentially one lawyer, and the fees split, and you can get it done before you have to do all this formal stuff.
Thanks. Yeah, I think mediation also, not to knock arbitration, which is a very efficient way of resolving disputes, but on occasion, it will sort of serve to alienate the two parties because it is more confrontational, whereas mediation is a way of doing this without sort of burning your bridges sometimes in commercial relationships. So certainly has a place together with arbitration as an alternative means of resolution of disputes. And the last item I think we wanted to cover is important. It deals with the right of appeals of arbitration awards, because we are, of course, very concerned about the speed and finality of arbitration. And so we would like to see a process where there is limited ability of courts to review or revise arbitration awards. So I'd just like to ask the panel if they have any comments on that.
I think that's what sets arbitration apart from litigation, is the fact that it is final and you don't have endless appeals that can drag things out, and then if the appellant wins and you have to go back and retry the case or aspects of the case, it really is very time consuming. The flip side of that is with arbitration, it is final. And if you're unhappy with the result, there's really nothing you can do about it. So you have to keep that in mind. I think with the larger cases, a lot of the risk of having some odd decision is mitigated by having 3 arbitrators. Because generally among the 3 of them, you're going to come to a consensus that is in accordance with the facts and the law. If you have a single arbitrator, especially if it's a non-lawyer, that may not be as likely to follow. But in the larger cases, at least over $1 million, we default to 3 arbitrators.
Well, it is final. There's a few situations where it's not final. Joe can probably explain them, but they're very, very, very limited. One of them is, if you paid me off, right? And there's a suspicion that, my watches are too expensive, and
Let me see that.
it's a Casio.
Yeah, absolutely. I think that, to your point, that if you're looking for a long, glide path of protracted appeals and review and another bite at of the apple, arbitration may not be the forum for your particular dispute. We like to say that finality is a feature, not a bug of arbitration, and that's you go in, you get your answer, and you go home. It's enforceable. As you mentioned, there are ways to challenge, or we call it vacator, move for vacator of an arbitration award, but those things exist already within the legal framework of the Federal Arbitration Act, the Florida Arbitration Act, and we don't need another rule in the IYAC telling us how to deal with duress and Casio watches and things like that.
You mean Patek Philippe's?
Only
Well,
Patek
and there are
Philippe.
obvious issues that sometimes would require post-final hearing review, and that's, for example, a mathematical error. If in calculating the damages, adding them up or multiplying them out, whatever it is, if there's a mathematical error, you're always able to go back to the arbitrator and ask to have that corrected. You will never have the chance to re-argue on the merits. That's not the purpose of the limited appellate rights that do exist, but gross errors like that can be corrected. And frankly, I think that's the way it should be. I think, as Charles said, if you have to think about it at the beginning when you're writing the contract, or do you want arbitration or do you want a judicial resolution? And if you pick arbitration, you know it's going to be quicker, less expensive, but it is final. That's the end of it.
Okay, thanks. So I think we are probably running out of our time, but let me just summarize where we are so far. So these new rules, I think, will result in greater efficiency, reduced reliance on more time-consuming mechanisms, as in the existing rules. There are simplified rules for the appointment of arbitrators. The fees and the procedures are commensurate with the size and the complexity of the dispute. The rules are easy to understand. They're in modern language, unlike a lot of the
Thank
older
you,
rules.
Lois.
Thank you. I'm going to thank Lois. And they give the arbitrator a very strong case management authority. So I think we can look forward to having a really sound set of rules going forward in the future. And as Joe reminded me, Lois Henderson, who was with the IYAC administration, was responsible for the initial drafting of this. It was a Herculean task, and I think she's done a spectacular job. But as I mentioned, we are still under the process of reviewing these, and we are obviously open to changes or suggestions for additions. If you have any thoughts, we'd be happy to hear from you on that. I don't know if we have time for any questions.
If you have a question, please raise your hand. Wait for the mic.
Hey guys, couple of questions on the when you talked about immediate relief, you lost me. So in layman's terms, not lawyer terms, what's that mean? And then AI, is it being used now at all, or it's coming?
Let me start with the immediate relief, because very simply, the reason for that is that if you are arbitrating a case, you want to make sure there are funds available at the end of the day to satisfy an award. And in cases where your counterparty may have signs of insolvency or may have a tendency to, let's say, destroy evidence, you want to have that preserved at the outset. Often you can't wait until a panel is formed, even though the new rules make it very efficient to appoint the arbitrators, but sometimes you can't wait. There's a need for immediate relief where a counterparty may be changing its corporate restructuring or trying to avoid ultimately satisfying an award. So that's why you need to have the emergency relief, which is enforceable by the court. So it's a powerful tool in those kind of cases. And believe me, they do come up.
Yeah, I can give you a specific example. When a boat is sold, the obligation to pay the commission is a corporate obligation, usually. So the funds flow to that corporation. How long do you think they stay in the corporate account, right? So I had a case involving a commission that was payable to somebody in a foreign country, a foreign corporation, and the only way to protect that was to take immediate action.
AI?
Yeah, AI is not like winter. AI is here. And I use it myself, and under the ethical guidelines that I adhere to, I am fully transparent with the parties and the attorneys who work with me on the arbitration cases that I'm presiding over. And yeah, it's here. It's 2026, man.
And have you found mistakes?
Oh, absolutely. AI is like a first-year law clerk or worse. And you have to review everything. You have to check it. I get into arguments with mine and tell it that it's lazy and stupid and I'm not paying it this week. But yeah, there's absolutely mistakes, and they're easy to find because, get it, there's AI to find the mistakes as well, including, by the way, lawyers, for your citations. There will be no hallucinations if you're in front of me, because I'll run it through AI and it'll tell me that that case is made up or doesn't stand for the proposition for which you cited it.
It actually happens. It happens with regularity. Made-up cases or cases that do not support the proposition.
Or even just the, kind of the final conclusion. And I was looking a couple of days ago at whether the Americans with Disabilities Act applies to a foreign research vessel with an underlying U.S. UBO. Unusual situation. I asked the question twice. First time, yes, definitely. Second time, no, it doesn't.
Was it with the same AI tool?
Yes, same IA tool. I just asked it slightly differently. So, it gives you, AI gives you a draft and it makes some interesting points, gives you things to follow up on, but you don't just cut and paste into some sort of legal document.
Duncan, as the only English lawyer, I think, in the room, I feel I need to say I'm interested to see that the IYAC rules have developed in a similar way for yachting disputes that the LMA rules have evolved for shipping disputes, and I applaud that. I was interested in two things. Have any of those 16 awards had a challenge to the Florida court? And what do the panel think about the problem that commercial awards are more likely to be written in a way that can be challenged just because they don't have the lawyer's experience?
I think there's one being challenged right now that I'm aware of. I was told is going to be challenged. And it was interesting because I think the conclusion was like totally wrong. We actually, I have to be careful what I say, but we declined the case because we thought it was a loser, and it ended up being that we were, well, at least the arbitrator thought we were wrong, but I'm told it's being appealed, and hopefully some judge will say we were actually pretty smart.
But on what basis is it being appealed?
I can't get into it.
Okay.
Well, the basis is that I can't say that the arbitrator didn't know what the hell they were doing.
How dare you? And to your point about commercial awards being written in a way that they're more challengeable, of course, Florida, we don't have the manifest disregard for the law requirements or anything like that, so the arbitrator can be wrong on the law, and still the award is binding. But I do think that ultimately the award writing process is teachable. And we can certainly coach up our men of industry and women of industry if they feel uncomfortable with, writing awards. So we can have, and we've discussed this, right? Having some training programs and seminars, webinars, whatever, to sort of coach folks up on what is a, bulletproof award, so to speak.
Okay, but no offense to our colleague from England, but if you have an accident in the intercoastal waterway, I think it's probably more practical to arbitrate your dispute here in Florida than in London. All due respect to the LMAA, but I think we definitely have an advantage in that respect.
Yep, two quick ones. When are these rules intended to take place? I might have missed it at the beginning. And two, do you find right now that there's a need for more mediators or arbitrators specific to our industry?
I don't know when the final rules will be. I look to our godmother Lois, when we'll get them finalized. So I don't have a number for that.
But, well, the default of where it takes place is Fort Lauderdale and Florida law. But you can change it. In all the contracts, you can just fill in the blanks however you want. And what was the other question?
Are there enough
Need
arbitrators?
mediators
I
and
think
arbitrators.
I think right now with the roster that we have and the demand for arbitration, there are enough to handle all the situations that have been presented. There are some arbitrators that end up working more than others, but as this the usage expands, then yeah, we'll probably have to bring in more people.
Thank you very much.
Speaking of AI, I'm organizing a yacht management advisory committee for IBA on the tails of the CPC and the CRC, other panels that are other committees that I've organized. Yacht management panel, and so decided to put an article in the Compass while they're taking their picture, in the Compass magazine about it. And I asked Grok, you know Grok? Okay. I asked Grok to say, animate a picture for me of somebody standing with a clipboard that looks like a yacht manager talking to a captain on the bridge of a yacht. And it came up with this fantastic picture, so I sent it over to IBA staff. And then I noticed on the epaulets, they were short one stripe. And on the sleeve of the captain, short one stripe. So it's there, but not in all cases. Anyway, I too am an IYC arbitrator, certified arbitrator. And I want to just pay homage to our steering committee for this seminar, which was comprised of David Maass, Chris Anderson, and Michael Moore. Let's have a nice round of applause. They put this whole template together. And with that, I'd like to introduce a very familiar name and face to us. David Maass is a board-certified maritime lawyer, shareholder at Ollie Moss in Palm Beach, focuses his practice on superyacht transactions, and on and on and on. Take a look at the bio notes on all of our speakers. David, thank you.
Good morning, everyone. The second panel we have this morning is on tariffs and the superyacht market. I see one of our panelists. I see two of our panelists. I see all three. Okay, we're good. I'll go ahead and introduce everybody. First, we have Jennifer Diaz, who is the founder and president of Diaz Trade Law. She assists businesses with customs compliance and responding to customs enforcement actions. Then we have Umberto Bonavita from Robert Allen Law, partner at Robert Allen Law, I believe also the president of Robert Allen Law. He advises not only yacht owners, but also builders, dealers, distributors in the U.S. market. And then we have Jay Reynolds, the president of JP Reynolds Company, which is a customs brokerage and freight forwarder. We're going to be talking about how customs have affected our industry and how the industry has responded, the tools that are available to avoid or mitigate the effects of the tariffs. So just to start by way of background, last year on April 2nd, I don't know if you all remember, but that was Liberation Day. That was when President Trump announced that there would be sweeping tariffs on foreign goods. He relied on several different statutory authorities, but for most of the tariffs, he relied on the International Emergency Economic Powers Act, or IEEPA, and those are the ones that probably affected our industry the most. Those tariffs were challenged in court. In February of this year, the Supreme Court held that the tariffs were not a lawful exercise of the president's power under IEEPA, and the same day, the president used a different statutory authority to impose pretty much the same tariffs. And so we will talk about where we stand now, what the situation is, and again, how people have responded. So we will start with Jen. Jen, do you want to? Oh, clicker. Jen, could you walk us through the tariff decision and where things stand currently?
I will. Hi, everyone. How many have heard about the tariffs? Yay! How many have had tariffs keep them up at night on Friday afternoon? That's when we seem to get the most in terms of decisions on what's going on. It seems to be Friday evening, Jay. I don't know who's behind this, but they have a moment. They have some time to ruin our weekend. So there's so much going on with this, and this is news every day. Keeping up is one of the hardest portions of this. Making sure that you are following somebody that's keeping up with this madness is really essential because it changes second by second. There are times in which I'm giving a presentation on the topic and it's literally changing at that very second. So I consistently say, this is up to date as of right this very second. If anything else changes after we're outside of this room, I am not responsible for that information because this is one of those crazy times where there is news literally second by second. What I thought was incredibly interesting is I pulled census data for yacht imports just up to the subheading 8903. Just for most yachts, this covers motor, no motor sale, and so on. And Mexico was your largest trading partner in 2024 and now in 2026, but Italy beat Mexico in 2025, and I think tariffs had a little something to do with that when you look at the amounts. So when it comes to the actual decision that we were talking about on February 20th, the Supreme Court issued their decision mirroring the lower court's decision, basically saying IEEPA bad. Now, the reason why is because these are all the tools, and this is one of the fun questions is, okay, but there are going to be other tariffs that replace this tariff, and how do I keep up with the tariffs, and which one is it? 301, 232, 122, what are the numbers? What do they mean? How does it all working? So the deal with IEEPA is there has to be an unusual or extraordinary threat to national security. How many of us, I mean, it doesn't even matter because the Supreme Court and all the other courts said not so much because the prerequisite is there has to be a declaration of the national emergency, but there also has to be a consultation with Congress. And that was 100% left out. So what the Supreme Court held going backwards was not so fast, buddy, because within the IEEPA declaration, under a declared emergency, a president may, and this was the key, in Chief Roberts' opinion, he said there's a 16-word gap. So 16 words is what made this decision, because between regulate and tariffs, and like importation and exportation, what you're not going to hear is the word tariff. So what does it say? The president may regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, and exportation. So what the court said was, amongst all of that, if Congress really wanted to give you, the president, the power to impose tariffs, they would have put that word in there. That word isn't in there. That means just because you declared a national emergency doesn't mean you have the power to impose the tariff. Now, here's the one fun part that SCOTUS left out. You know what was in? The dissent talked about refunds, but guess what didn't? The majority opinion. So now, that's the fun part that's going on here. How many of you imported a yacht and paid IEEPA tariffs maybe from Mexico or Italy? Any of you? Because if you did, let me guess, you want your money, honey, right? You want a refund like everybody else. So I'll talk more about what that is, but the fun part for this is what SCOTUS, the Supreme Court, did is they said the mechanism, IEEPA, was not used properly, can't do so. Okay, we all agree. Lower court said that, appeals court said that, SCOTUS said that. Great. That doesn't mean the refunds are just going to go to your bank account and you just automatically get them. And that's where confusion lies because there's stuff. If you were the importer of record, you got to do stuff. So now the confusion is Customs has gone on with this plan for refunds. There are 330,000 over importers that paid IEEPA tariffs. Does that sound like a lot? There's $166 billion at issue. Does that sound like a lot? Do you think our government just wants to give that back? No, not at all. What Customs has said is there are 53 million entries at play. And it would take Customs 4.4 million man-hours if they were to manually deal with refunds. Who has that? So what happened is the lower court, it said, is saying, okay, we have the Supreme Court finding IEEPA bad, great, and Supreme Court throw us back down to the lower court, Court of International Trade, and says, Court of International Trade, you deal. A couple of really key points here. One is the president had the ability to request reconsideration from IEPA bad February 20th decision, right? They didn't do that. Whether or not that was purposeful or not, I don't know. I thought that was super interesting because we expected a little more volatility with the actual SCOTUS decision. SCOTUS decision stands, but now here's the important part for everybody who wants their money, honey. The March 4th court order from the CIT says, here's the deal. Here's the actual lingo, so I can read this to you and you can understand how fun our life is. So Jay and I can relate to this because this is our everyday working world. The order lingo, with respect to any and all unliquidated entries. How many of you know what an unliquidated entry is? The regular public doesn't understand and speak unliquidated entries, but fine. CBP is directed to liquidate without the IEPA tariffs, but for any liquidated entries where liquidation is not final. How many of you know what liquidation is not final means? Anybody? Yeah, exactly. Which is 90 days after liquidation, shall be reliquidated without IEPA. But here's the fun part, right? That doesn't take care of all the entries. Because now how many of you are monitoring your liquidation schedules? And how many of you, post 90 days liquidation, have A, filed a claim or done anything else? And now here's the extra fun part to make a little bit more fun. What has the government said? It is not our position that every single entry and every importer will get a refund. Government said this. Okay, how does this all work together? Well, guess what? The government still gets to appeal the order. It's not over yet. So we have this order and the government has 60 days to go back to say, wait a minute, judge, I'm not happy with how you think liquidated and unliquidated entries should be given refunds. We fully expect that to happen. But if you were the government, would you wait until the 60th day to make everybody's life miserable and make it a Friday afternoon for fun? I think that's what's going to happen if I have my dollar bet. So I'm happy to place bets on the side. We've done a lot of bets because it's either coffee, chocolate, alcohol, or bets or something to keep your sanity in this day and age when things are moving so rapidly. So to answer your question, SCOTUS has said tariffs bad. Customs has said, I have a plan for refunds that I'm happy to talk about because that plan is a proposed plan. I don't want anyone to bank on this proposal because guess what? I expect an appeal. I expect that the government's going to fight and say, if you're not in court, not so fast, honey. I'm not just giving you your money back, and if you're not filing an administrative protest, also not so fast. So just because the government is creating a mechanism to have importers request refunds, this isn't going to be an automatic, you paid it, thanks so much, you're owed it back, thanks so much, here's your refund. This is going to be a hassle and steps for importers to take to demand their money back. And if you don't have the right counsel guiding you every step of the way, like yesterday was the time.
So with the IEPA tariffs, they've been held unlawful. There's litigation continuing in the lower court, the Court of International Trade, about the process for refunds. In the meantime, as I said, Trump has reimposed tariffs under Section 122 of the Trade Act of 1974. Jen, can you tell us about those tariffs, whether they might be vulnerable to legal challenge, and what happens if they're struck down?
For sure. So obviously there's more litigation, and more litigation. But just to go back, because there were 2 points that I missed that are really, really important. How many of you know about ACE that are importers? And this is where the stats also are really bad. So we have 330,000 people that have paid tariffs, and we only have 21,000 of those 330,000 that are actually prepared to receive refunds as of a couple of weeks ago when CBP filed this declaration. That's bad. So if any of you in this room happen to have paid tariffs, then I beg of you to sign up for ACE and to put in your ACH information. If you have a foreign entity that has paid tariffs, you need a U.S. banking institution in order to accept refunds in ACH. Only 21,000 companies have set that up, okay? So what Customs has said is if you want a refund, the process I'm setting up is the importer has to file the request in ACE, meaning A, you need an ACE account. The importer has to list the entries that are applicable. B, you need to know and not just count on Jay to make sure, because if you cheat on him, he's not going to know anything else. So don't cheat on Jay if you're using Jay, because he can't pull a report for you of all of your other entries. And then make sure you, importer, have a U.S. bank account as well. This is all going to be challenged because we have a lot of foreign clients that have paid, and what? They shouldn't get a refund because they're not in the US? That's fair? All of this is going to be in contention. So now, going back to the appeal process itself, like, by the way, Customs has to give updates every week on the status of their creating this fancy CAPE system. They're 63% done as of March 19th. March 31st, the next update Customs is going to give about their fancy schmancy portal. Up until then, make sure you get your ACE account, sign up for ACH, make sure you file suit. We're yelling at people to file their own claims. We filed almost 100 claims itself. There are about 3,000 importers in court. I don't know why there aren't hundreds of thousands of importers in court, and the judge obviously says he doesn't want a bunch of court cases because it's inconvenient for him. Too bad. Sorry about your inconvenience, judge, but you want Customs to be overloaded with protests. So 53 million protests makes a better decision than filing claims in court and having court orders to Customs? I don't think so. So we're yelling at people to file claims and to make sure that you are protecting your refunds, because if you're waiting for all of this dust to settle, what you're going to do is give the government what it wants. You're going to time bar yourself out of being able to receive your refunds. So now, in terms of other avenues the government has, this is the laundry list of tools. There's a lot of tools. So when 122, right now, 122 is the next tool the government used when IEPA's gig was up. All right, so IEPA bad, fine, let's go down the list. 301 is what's popping up next, now that 122 is also going through litigation. So 122, what are we supposed to have? A balance of payments deficit. What is it? There's a 15% cap. So there are a lot of threats. No, if you see it on Truth Social, it is not gold. That does not mean it's an actual executive order, a proclamation, and it's legit. It just means it's a threat. Lots of threats on Truth Social. We have to follow that every day. Just because it's threatened doesn't mean it's real. 10% was threatened to be 15. 15 is the cap. And no, it can't go beyond 150 days without congressional intervention. But what's going to happen? Now you have 22 states that have yelled saying, or 24 states that have filed at the Court of International Trade, and also importers. So what's happening? More litigation. More saying 122 not correct, not being appropriately used. So what is the government doing? They're starting 301 investigations into 60 countries saying there's a forced labor issue. What do you need for 301? Unfair foreign trade practices. What does that sound like? Sure, forced labor. Has anyone heard of the Sweat and Toil app from the Department of Labor? Love the app. Highly recommend you download it. It's free. And it lists every country that has an alleged forced labor issue. There are hundreds of countries on that list. Guess who's not on that list? US. How many of your kids have ever worked in your business? Because Mexico, they have a bunch. 15 different issues with forced labor. Our U.S. government does the investigations. Our U.S. government updates that list every couple of years. How many countries are on that list? A lot. So now we have 60 new countries on a Section 301 alleged new tariff that's going to come up, and that's reviewed every 4 years. Bottom line, are tariffs going away? No, it's just going to get more and more creative, and it's going to be litigated more and more. We have an active 301 lawsuit from 2018 China tariffs. Are those still in existence? Yes. Is that going to the Supreme Court? Probably. This isn't going away. It's just going to get more and more creative. And unfortunately, it's like lawyers that win in this game and importers that don't have the right counsel yelling at them and guiding them into what to pay and what to challenge. You're going to be screwed. So get your right guidance available, because the CIT process for refunds isn't happening overnight. The appeals process is absolutely still ongoing, and more lawsuits will absolutely be taking place, and you're going to have to figure out if you want to get on board for those.
All right, in light of all the turmoil surrounding tariffs, Jay, I'm going to ask you what I hope is a straightforward question. What is the current rate of duty on, let's say, yachts from Italy, the Netherlands, or other countries in the EU?
First, I'd like to ask that my phone number be removed from any of the... I don't want to talk about that stuff. And you're absolutely right. It's always Friday afternoon when this stuff hits. It's amazing. As of 7 o'clock this morning, the duty rate on most yachts, motor yachts, is 1.5%. The assessment, Section 122 assessment, is 10%, with a threat at any time to go to 15%.
And then China has an additional 25%. That actually kind of reduced tariffs, especially for the EU, which had a max of 15% already. So it's actually looks a little better right now, but the issue is that the unknowns of what can happen. And I don't, honestly, I feel very sorry for dealers and manufacturers and brokers that are trying to plan for the future, because I don't know how you do that in this market. You know, it's a guessing game. This afternoon, we could get a signature on a piece of paper that changes it from 10 to 15%. And there it is.
And Jay, just to be clear, the Section 122 tariffs, those do stack on top of the 1.5%, so it's a total of 11.5%?
Correct.
Because
Yes,
before the IEPA tariffs, it was just a flat 15.
that's correct for the EU.
But the IEPA is still stacked. Your general rate of duty is that 1.5, and that's on your classifications. You have your general rate of duty. This is a special edition. So no matter what, it's always 1.5 plus.
Okay, and Jay, I just have a question, something I was curious about. What does it look like from your point of view when these things happen, when something appears on Truth Social or on February 20th when the Supreme Court decision was handed down? How quickly do CBP officers in the field respond to that, and what does that look like?
I'm actually kind of impressed at how fast Customs has dealt with this. You know, their notifications are pretty quick to put in writing on Federal Register notice or Customs message systems how they're going to deal with situations like this. And then, the increase, is there going to be kind of a little moratorium effect while this takes place because you already have cargo on the water? You've already purchased it, the cargo's on the water, and now you're going to get hit with the 10%. So Customs has been able to react, I think, pretty impressively about it. It's a battle. One of the things that we're being hit right now with is the idea of the refunds. As soon as IEPA was cut down, I just one phone call after another, one email after another with from our customers saying, "How do I get my money? How do I get my money? How do I?" And now I've got to work with those folks and number one, tell them as Jen says, everything's being challenged. So right now, this is the methodology that looks like it's in place. We're going to file a protest, and you've got to sign up for all these, the ACH account and the ACH account with Customs, which is honestly just a huge hassle. But we've now got to walk our customers through that process just to get them prepared. So the answer is, don't expect a refund anytime soon, but be prepared.
Jay expressed sympathy for dealers and distributors who have to deal with this now. Umberto represents many of those dealers and distributors. Many of these companies used to import foreign-built yachts, typically smaller production boats, from abroad and then hold them in inventory in here, but with the tariffs in place, that's no longer economical. So how are they responding?
You're as busy and nauseous as I am. With all due respect, Jennifer.
Umberto.
Okay. I mean, it was an excellent presentation, and not too many attorneys could have digested and crystallized it as well as you did. But I got nauseous. And the bottom line is, I believe yachts got kind of tidal waved into all of these tariffs and duties, with steel, lumber, automobiles, computer parts, roofing materials. But if you think about it, yachts should be exempt. But they're not. Maybe eventually, and I hope somebody will exempt them. It's something the IYAC should consider in the lobbying. But if you really take a step back, yachts should not be subject to duties. The whole concept of tariffs and duties for Trump to increase it was really two things. We're going to boost manufacturing in the United States, and we're going to increase revenue. It's a tax. Tariff is a tax. So we'll tax luxury goods, and we'll increase the government coffers, and it's great. But that's not how it works. Because at 1.5, 1.6%, which is, back in the normal days, a lot of yacht owners were willing to pay that duty and import the yacht. And the government was seeing a lot of revenue because they were paying the duties. 1.6% of a purchase price, that's not bad. Now they want, well, first it was 17% for a while. Now it's at 11 and change. Nobody's going to pay that. And frankly, nor should they. And yachts are, you know, they're ships. They're movable. They don't stay stationary. So all the things that you would consider that why should somebody import them? And I think in our experience, we'll start with yacht owners, and then to your question, dealers and distributors. I think for every 10 yacht owners, maybe 9 out of 10 right now are not going to import. They're just not. Unfortunately, there are exemptions. And that's actually, Jennifer's PowerPoint, in my opinion, is an excellent paid advertisement for all the foreign shipping registries. Marshall Islands, Jamaica, Cayman, Bahamas, because now they're seeing an uptick in registrations because nobody wants to pay these duties, and fortunately, there are exemptions. And it's actually absurd if you think about it, because I'm seeing yachts in the Great Lakes, you know, with the Marshall Islands flag, Bahamian flag, in the middle of Lake Erie. I mean, it's absurd if you really think about it. And they're able to farm flag, they're able to renew the cruising permit once a year. So they're not dealing with the refunds, they're not dealing with paying tariffs and duties because they're lawfully exempt. So really, the US government, in my opinion, is losing out. On the dealers that bring in stock inventory, they were really impacted initially, and they had to come up for air. They got socked in the head and say, okay, how are we going to deal with this? And essentially what they did is they looked at, you know, excellent brokers like Jay Reynolds and said, what are our options? And what we're seeing really is 3 tools. They're using the foreign trade zone. So some dealers and distributors have actually gone out and applied and gotten their own FTZ, the foreign trade zone, so that they don't have to